Okay guys, so today we are going to be discussing about external aids to interpretation. So we discussed about different rules and principles of interpretation, different maxims which help judges in how to approach interpreting statutes. And apart from that, we also looked at different internal aids to interpretation. So, and after that, the next important relevant topic would be external aids to interpretation. Now, as opposed to internal aids that we have discussed, which you find within the four corners of this statute, ex visceribus actus, external aids are what can be considered by the judges in coming at right conclusion relating to what the intent of the legislature is. Okay, however, they are used only when all other paths are not sufficient, all other measures that we have discussed are not sufficient. Only then do they look take help from external aids to interpretation. Now all the external aids that we are going to discuss have the same value. They all have different value, and we are going to look at them as we take specific external aids. So what are external aids? As we discussed, they are not internal to the statute itself. Okay, they are outside of the statute, and there could be many such examples of external aids. So in the interpretation of a statute, if a doubt or uncertainty as to the meaning of the legislature arises and that cannot be removed by consideration of the act itself, basically all the internal aids that we discussed as well, and its various parts, so the act and its various parts, then recourse may be had to the extraneous facts. So facts which are not internal to the statute and hence external aids. So extraneous facts, circumstances, and means of explanation for the purpose of determining the legislative intent, but those only are admissible which are logically connected with the act in question, or authentic or inherently entitled to respectful consideration. So as I told you, it is not used when the meaning is crystal clear. Okay, there is no ambiguity, there is no doubt. Okay, and when we come across such ambiguities and doubts, we then take help from use all the principles that we discussed, all the rules that we discussed, all the maxims comes at rescue, and then we also look at different parts of the statute. But if those are also not sufficient, those are not enough, then we can have recourse to what are known as extraneous facts, circumstances, means of explanation. To do what? Not to legislate, okay, not to create the law, but to find the true intent of the legislature. So they might tell you sometimes they might tell you the purpose, and then in the light of that purpose, you can then, trace the legislative intent of the particular provision of the law. But not all such external aids will be of the same value, as I told you. So only those which are logically connected with the act in question. Okay, only those will be relevant, and only those will be admissible to a certain extent. Okay, and there will be variations in relation to the degrees to which they are, relevant. So yes, if they are, then they are, as has been said, entitled to respectful consideration. So the extrinsic act or circumstances which it is permissible to consider in the construction of ambiguous statute, not where the meaning is clean, but only where the statute is ambiguous, must be either logically connected with the act in question. So what are those? So maybe there was a legislation previous to the legislation which is in consideration. So you may have statute in perimetria, or it must be authentic, okay, authoritative. So such as legislative declaration of the meaning of the law. Or it must be inherently entitled to respect or to weight. by reason of universality of its acceptance, or prevalence, or by reason of its official character. So all those factors, okay, we'll look at different examples, then you will see which are those, okay. Then they are, worthy of being considered in the considered for the interpretation of statute. So a general usage, a practical construction of the executive department of the government, and an opinion of the legal advisor of the executive. So these are certain examples, given in the book that I had referred to earlier. So in English cases. But apart from that, okay, we have many other authoritative documents which could come to rescue. So different trouble preparatoire, okay. So different historical documents could definitely be of help. Okay, now it depends on individual cases, and where we'll find the extent to which they have been given importance to. So parliamentary history, legislative history, so many factors could be taken into consideration. The debates, so for example, Constituent Assembly debates, all those things, as you can clearly see, they're not part of the statute, or for that matter, Constitution, if it is the Constitution which is being interpreted, but then they are nonetheless able to tell us of certain information that can then help the judges in identifying the the true intent of the legislature. So yes, so let's look at some of the external aids which are of help. So if you remember earlier, we discussed about when we started our discussions, we talked about plain meaning or dictionary meaning. Okay, now dictionary is not part of the statute, but in order to find the meaning of the words in a statute, you may find the meaning from the dictionary. So dictionary could be an external aid to interpretation. However, as we discussed, the dictionary meaning will not necessarily supersede what has been originally intended in the legislation. So only when confusions, ambiguities arise, then this could be one such external aids. So dictionary may be permissible to look for a meaning of a term in the absence of any definition thereof in the relevant statutes. So statutes, in the introductory portions, do provide definition of different terms used. But then in the absence of such definition, quite often it might be necessary that dictionaries are referred to. But where the word has been statutorily defined or judicially interpreted, then we refer to that meaning. However, even in this situation, in specific contexts, we have to be careful that it is not that specific meaning which has been given which is to be used. So we have to keep in mind that words could have multiple meanings, and so the context might be important. So the context tells us that what meaning is to be given to a particular word. So this has been said in State of Orissa versus Titagarh Paper Mills Company Limited, 1985. So yes, and in that case, it has been reiterated that we have to keep in mind that the words could have multiple meanings. So the context might be important. So do not just look at dictionary meaning. You also have to look at the context in which it has been used. So a word might have been used in a particular sense in which it has evolved, in judicial decisions, or if it applies to any specific industry, if you remember we discussed, then we probably have to go ahead with that specific meaning that it has acquired, rather than going ahead with any other technical meaning. So Justice Coleridge had said in R versus Peters in 1886 that dictionaries are not to be taken as authoritative exponents of the meanings of words used in the Acts of Parliament, but it is well-known rule of the courts of law that words should be taken to be used in the ordinary sense. Okay, so dictionaries do not themselves have any authoritative, influence. Okay, they do not. So they are not to be taken as authoritative exponents of the meanings of the words in the acts of the parliament, because it's quite possible that the parliament, while enacting a particular statute, has given a different meaning than the one that you can get from the dictionaries. But at the same time, if that's not there, then, as has been said, there is a well-known rule of the courts of law that words should be taken to be used in their ordinary sense. And where do you find the meaning in the ordinary sense? You find it in the dictionaries. But then remember the rule of context. Okay. Similarly, in an Indian case by the name CIT versus Binoy Kumar, AIR 1957, SC 768, it has been said that the definition of a term in one statute does not afford a guide to the construction of the same term in another statute, and the sense in which the term has been understood in several statutes does not necessarily throw the light on the manner in which the term should be understood generally. So obviously different statutes might refer to different persons, class of persons, different subjects, objects. Okay, so the words used for that specific purpose is not to be used generally in the interpretation of all other statutes. That's very understandable. Then in such situation, where do you find meaning from? In that situation, you will probably go for a source which is much more neutral in that sense. Okay, so in such case, obviously dictionaries could be of help, but obviously subject to and the other restrictions, the other circumstances that you have to keep in mind, and only then, if all those fits, then you can definitely take help from the dictionaries in coming at a right conclusion about the words about the meaning of a particular word in a statute. The next important source, would be Travaux Preparatoires. Travaux Preparatoires. What are Travaux Preparatoires? So basically the preparatory documents. So it seems to be a French word. Okay, and what would be the interpretation? What does UN say about Travaux? So there are many different meanings that you can find for this word. Okay, so in the it basically means the preparatory document for a particular statute. So the preparatory works, okay, all those are Travaux Preparatoires. So some of the web-based sources said that one US legal says the literary meaning of this French term is preparatory works. It constitutes the materials used in preparing the ultimate form of an agreement or statute, especially an international treaty. So yeah, so preparatory works, whatever was used in the preparation of a particular treaty, statute, etc., etc. So the same is also a French word, and the United Nations website says Travaux Preparatoires is the name used to describe the documentary evidence of the negotiation discussions and drafting of the final treaty text. So what are those? So you find them in the documentary form, the evidence related to whatever negotiations happened, discussions happened in the preparation of the final treaty. So we could use the same when it comes to interpretation of statutes as well. So whatever negotiations happened before the statute was finally enacted. So obviously the importance given to it will vary. Okay, so when it comes to interpretation of international treaties, then the Travaux Preparatoires will have different value than when it comes to statutes, domestic statutes. So Vienna Convention on the Laws of Treaties says that these documents can be used to supplement the interpretation of treaty when the meaning is ambiguous, obscure when reading the treaty alone. So it is only in those situations, even in the interpretation of treaties, it says it's only in the interpretation of the treaties when there is ambiguity or the meaning is obscure, only then the interpretation can be done, okay, in the light of these documents. So yes, there could be many different such documents, some historical records, the debates, discussions, which if they have been put on record, etc., those could be evidence of what has been intended in the final piece of legislation. Now the thing is that here's a word of caution at the same time, okay, that not everything that has been discussed do finally find their place in the statute, okay. So we have to be very mindful of that, okay, that what has ultimately found its way into the legislation. So they could be upheld, but they do not supersede what is there in the legislation. That's the idea. So yes, the travaux préparatoires, the preparatory works, documents, okay, or surrounding circumstances, all those factors could be of help, okay, the existing state of law, parliamentary history, all those could be of help in interpreting a particular statute. Now remember mischief rule, if you remember the mischief rule, even the mischief rule is kind of based on external aid. It says that you have to look at the state of law as it existed before the enactment of the law, whether it is under the common law or under the statute law. So yes, in those situations you refer to something that is outside of the legislation, okay. So yes, all those definitely come under the external aid. So yes, travaux préparatoires or the surrounding circumstances, the previous state of law, the parliamentary history, debates, discussion, all those matters do matter in the final interpretation of the statute. But only when there is ambiguity, as we saw, okay? Only when there is some doubt as to the meaning of a provision in a statute. So the rule is that in order to arrive at the intention of the legislature, the state of the law and judicial decisions antecedent to and being handed down at the time of the statute was being passed are material matters to be considered. So yes, that's something even your mischief rule had said earlier, if you remember. So what was the state of law previous to the current law? Okay, judicial decisions in that specific area of law. All those, until the law was created, would definitely help. Okay, they do not supersede, as we discussed. Okay, they help you in finding out the purpose for which the law has been enacted, and in the light of that purpose, you can then find out the legislative intent in a particular provision of the law. So the evidence of matters relating to surrounding circumstances and historical investigation, so the reports of the select committees and the statement of objects and reasons when a bill is introduced, all those factors could definitely be of help in the interpretation of a statute. But then we have to be very careful that all these things do not ultimately make their way into the legislation. It's a long process. You have multiple readings that happen, debates, deliberations happen. So, and ultimately the final piece of legislation is enacted. And what is enacted need not necessarily be in complete consonance with the statement of objects and reasons with which it has been enacted. Okay. With which the bill was introduced. So in such case, we have to be extremely careful. But then, as we have seen, if confusions arise, okay, if there are doubts, then definitely it can be of help in finding out the purpose and then ultimately the intent of the legislature. So bills, as it has been introduced, reports of select committees do help, okay, but they are not legitimate material to be called in aid at the construction of a statute. And why is that? Because there what has been introduced, that's not the exact thing that has turned into the statute. So we should focus on the statute. Okay, we do not get to go back and ask those who made the law what you intended, because they are probably the most confused lot. Okay, now they are not allowed, then how is it possible that the bill as it has been introduced and the reports of the select committee would supersede what has been ultimately enacted? That is definitely not the legitimate material to supersede what is there in the statute, but then they could be of help in finding out the object and purpose. Okay, so only to that extent is it relevant, but they're not legitimate material that will supersede the construction of a statute. What about parliamentary debates? Well, they're not admissible directly as something as evidence of what has been intended. Why is that? It's quite simple. When parliamentary debates happen, if at all it happens, the kind of legislature we have, but if at all that happens, and whenever it happens, you have views. For a particular provision, there might be views for and against. There might be lots of negotiations. That happen, and then ultimately the law is enacted. So what is debated, may not necessarily find its place exactly into the ultimate form of the statute. And the legislature intends with the law, the meaning of the law when it enacts the law. Not in the debates that happened before that. Before the enactment of the law. So that's what concerns. So parliamentary debates and as it happens on the floor of the legislature are not directly admissible in interpretation of a statute. So whenever we have plain words, so in such case the plain words will not be restricted by all these extraneous considerations. So even, policy considerations will not justify superseding or negating the plain words which are quite clear in the statute. Because once the legislation has been enacted, it lays down the rights, obligations of different parties, and those rights are to be given effect to, So if subsequently the meanings of these provisions were to be changed based on policy consideration, then what is not protected and what is not respected are the rights of parties, different parties, and that is against the idea of rule of law. So that's the idea, that when the words are plain, clear, in such case, even these policy considerations, so you do not look at the debates in the light of the policy in which the debate has happened, and hence meaning is to be given accordingly now. No, that cannot be done if the words are clean and clear. That cannot be done. Nor can you refer to the persons who have been who have been the ones who enacted the law. So it's said that in the construction of a statute, the worst person to construe it is the person who was responsible for its drafting. And so drafters draft, and then lots of debates happen, and ultimately the matter is voted, and then it is enacted into law whenever the president signs. And so drafters, and the thing is, so we have drafters and then we have the legislators who vote. Now the drafters' intention do not matter. It's not their intention that we are concerned about. Drafters may be expert in drafting a legislation in the best possible way, but it's not their intention that we are concerned about. It has been discussed, debated on the floor of the House, and then it has been voted on. So obviously what the drafters intended is not important for us, and they're the worst person. Even they might even get confused what they have actually drafted, and so that's not the legitimate source either. Now what about those who voted? Well, once they have voted, you remember we started with this idea that once the legislation has been enacted into law, bill is enacted into a law, then their role is functus officio. So we cannot then again go back and then say that tell us the clear meaning of this statute. But then, in the light of difficulties, okay, like ambiguity, confusions, okay, and when it is doubtful in nature, in such situation you may refer to some of these matters and not others. So in a case by the name S.C. Prashar versus Vasant Sen Dwarkadas, AIR 1963, SC 1356, Justice S.K. Das had made this observation that the statement of objects and reasons for introducing a particular piece of legislation cannot be used for interpreting the legislation if the words used therein are clear enough. So in such situation, do not go back into the statement of objects and reasons for which the legislation was introduced. Debates happened, the legislative intent has been exercised, and then it has been put into the form of the legislation. Okay, now you find the legislative intention from that legislation. If the words are clear, then all those extraneous factors have no value whatsoever. That's what has been said. Says further that, but this statement can be referred to for the purposes of ascertaining the circumstances which led to the legislation in order to find out the mischief, okay, what was the mischief which the legislation aimed at. So that's why I referred to the mischief rule earlier, that yes, all this could help you in finding out the purpose for which the legislation has been enacted, to address a particular mischief. So this statement of objects, reasons do not themselves supersede what is there clearly in the legislation. But if there are doubts, okay, then you definitely look at those circumstances to find out the mischief, okay, which was to be redressed through this legislation, and then you can, using the purpose, come to the right legislative intent in that particular legislation. So what about Law Commission's report? Now, Law Commission report, okay, themselves are not of much value, okay, so they are of value, no denying that, but they are not to supersede the legislation, okay. Law Commission report has been made, it may not have been, translated into legislation, not necessary, but sometimes legislations are enacted in the light of a Law Commission's report. So in that situation, if ambiguity arises in a particular provision of the legislation, then it has been seen in many cases that the Law Commission report is referred to arrive at the proper definition of a particular provision in the law. One very interesting example is Santa Singh versus State of Punjab, 1976. For SCC 190. So in this particular case, we are concerned about section 235(2), clause 2 of CRPC, Code of Criminal Procedure. So what does it say? It says, if the accused is convicted, the judges shall, unless he proceeds in accordance with the provisions of section 360, hear the accused on the question of sentence. So, on the question of sentence, the judge has to hear the accused, okay, and then pass the sentence on him according to law. Now, this has been the law in many other countries, okay, but was not there until then, okay. So, in this particular case, the question was whether adherence to this requirement, that hear the accused on the question of sentence, okay, whether that is mandatory. So in this particular case, the Law Commission report was used, and I quote from the judgment. It says, whether non-compliance with section 235(2) is merely an irregularity which can be cured by section 465, or is it an illegality which vitiates the sentence, having regard to the object and setting in which the new provision, that is section 235(2) of CRPC, was inserted into the 1973 code, there can be no doubt that it is one of the most fundamental part of the criminal procedure, and non-compliance thereof will ex facie vitiate the order. So it is in the light of the Law Commission report that this particular provision has been there, okay, in the code sense. Okay, so it is something that is mandatory. So the accused has to be heard on the question of sentence. Okay, and this conclusion has been arrived at in the light of the Law Commission report. Now, another case in which this same sentiment can be seen is the same. So what we have to keep in mind that yes, Law Commission's report are quite often there, but not everything might have made its way into the the ultimate legislation. But then when a legislation is enacted in the light of certain Law Commission, in the light of a Law Commission report, then it may be referred to arrive at the right conclusion regarding the true intent of the legislature. Okay, so that's the rule. Similarly, in State of Maharashtra versus M.F. Desai 2002 case, okay, it was said that the statement of object and reasons is undoubtedly an aid to construction, but that by itself cannot be termed to be and itself cannot be interpreted. Okay, so yeah, it could be referred to, but it will not supersede the legislation. So it is a useful guide, but the interpretations and the intent shall have to be gathered from the entirety of the statute. And when the language of the sections provide appeal to a forum providing an appeal to a forum is clear and categorical, no external aid is permissible in the interpretation of the same. So only when there is confusion can we refer to external aids and not otherwise. So yeah, it's the least important aid to the interpretation of the statute. However, when there is ambiguity and doubt, if all other aids, that is basically all the internal aids, not sufficient, then the judge may refer to external aids, but with a lot of caution. However, when it comes to constitutional adjudication, the picture is quite different, because when it comes to constitutional adjudication, a lot of other factors are at play. So one of the most important factors when it comes to constitutional adjudication is that judges have a much more say in those. Okay, so judges' political beliefs, ideological leanings, all those factors also play a part in how constitutional adjudications happen. And because the Constitution is not merely a legal document, but at the same time is also a kind of political document, and you see that the meanings are much more amorphous there, okay, than when it comes to other statutes. So in the cases of constitutional adjudication, judges might take much more liberty in interpreting the statute in the light of certain political beliefs, etc., etc. That's what happens when it comes to constitutional adjudication. So, for example, in Bachchan Singh versus State of Punjab, 1982, 3 SEC 24, I quote from the judgment, says that constitutional law raises in a legal context problems of economic, social, moral, political theory and practice, to which non-lawyers have much to contribute. When the judges are confronted by issues to which there is no legal answer, there is no reason other than a desire to maintain a fiction that the law provides the answer. So it's saying that in such case, judges maintain a fiction that the law provides an answer. So further says, for judicial discretion to be exercised in vacuum, immune from non-legal learning and extra-legal dispute, the judges must also consider while deciding an issue of constitutional adjudication as to what would be moral, social, economic consequences of a decision either way. The consequences, of course, do not alter the meaning of a constitutional or statutory provision, but they certainly help fix its meaning. So yeah, even there, okay, even when it comes to constitutional adjudication, we maintain, as if you were a judge, you will not say that you are creating the Constitution fresh, okay, or or adding something to it, but that this is the right interpretation. Okay, but quite often that right interpretation definitely happens in the light of certain other factors which cannot be completely ignored. Okay, so as has been said, okay, in the context of problems of economic, social, moral, political theory and practice, okay, all those factors definitely matter. So it says, for judicial discretion to be exercised in a vacuum, immune from non-legal, there is no reason for judicial discretion to be exercised in a vacuum, immune from non-legal, learning, extra-legal, dispute. The judges must also consider, while deciding an issue, the constitutional adjudication of constitutional adjudications as to what would be the moral, social, and economic consequences. If judges were to decide from within the Constitution, then should these matters become relevant? Well, even then it may be relevant, because the Constitution, as I told you, the document itself is not purely legal document. It's also a political document. It's a social document. So all these competing theories find their place within the document, and judges have to decide in the light of that. So yes, judges have much more room to play when it comes to constitutional adjudication. And even there, you will find that there are attitudes, though, among the judges. Some who believe that, Constitution is a purely legal document, that yes, how do we arrive at the right, right interpretation of the provisions of the Constitution? Well, how it has been intended, okay, how it has been framed by the what do you call it? Sorry, it's getting out of my head. The framers of the Constitution, okay? The framers of the Constitution. You have to find the true intention from of the framers of the Constitution, okay? So originalist approach. You find what has been originally intended. Whereas there are other judges tilting towards the left, who believe that, well, the ones who had intended, okay, are long dead, are in their graves now. Okay, why should why should we today be bound by something that has been intended by people all these many years ago? Now, this debate is much more pronounced in the US. Justice Antonin Scalia is known as one of those originalist, judges. We will have a discussion on this topic later on once we are done with these basics. So yes, those judicial attitudes, whether they want a dynamic interpretation of the statute or they are conservative in their interpretation, all those factors would also matter, and will basically tell you the degree of importance given to external aids. Now, in another Indian case by the name Union of India versus Navin Jindal, AIR 2004, C1559, and I quote, it has been said that insofar a Constitution Act is concerned, there is greater reason in giving to its language a liberal construction. That means you may refer to extraneous factors, so far as to include within its ambit the future developments in various fields of human activity, than in restricting the language to the state of things existing at the time of the passing of the act. So yes, when it comes to Constitution, because Constitution is a much more permanent document than any other statutes, which are very easily created and amended. The same, obviously amendment provisions are also there in the Constitution, no denying that, but then it's not every other day that the constitutional amendments happen, and when the changes in the society are much faster than the evolutions in the law, okay, then quite often liberal construction is the way forward. So judges take the liberty in construing the provisions of the Constitution in light of the changing developments, okay. So that's what has been said in this particular case. Similarly, Justice Kirby had in Abebe, A-B-E-B-E, Abebe versus Commonwealth 1999, okay, said that we are not bound to the imaginations of the men who, in the last decade of the past century, wrote the Constitution. It is governmental charter of today's Australians. So it's referring to Australian case, and then said that, well, why should we be bound by something which has been, said or written in the last century. So it's a much more dynamic approach, as you see, as opposed to others who believe in adhering to what had been originally intended. So similarly, in Lawrence versus Texas, 2003, Lawrence et al. Versus Texas, 2003, it has been said that the framers of the Constitution knew times can blind us to certain truths, and later generations can see that laws once ought necessary and proper, in fact, serve only to oppress. So in such case, that means judges have to take the liberal approach. So, and we will discuss the relevant, case laws later on when we discuss the debate between originalist versus, the dynamic, living constitution. Similarly, Justice Brennan had said that we current justices read the Constitution in the only way we can, as the 20th century Americans. We look to the history of the time of the framing and the history of the interpretation, but the ultimate question must be what the words of the text mean in our time. So another approach that believes in, the constitutional what's the word? So living constitution. That constitution, evolves with and changes with time. So meanings have to be attributed accordingly. So in such case, so as you see, as opposed to other ordinary statutes in constitutional, interpretation, all those factors are much easily, referred to by the judges. So. But then there are others who believe in the originalist idea. So quite often that means that you may also have to look at Constituent Assembly debates and speeches, and that also happens quite often. That also happens to find out what had been intended in the Constitution. So Constituent Assembly debates and speeches are also relevant in the interpretation of the Constitution. So one famous case is Keshavananda Bharti versus State of Kerala, AIR 1973. In which Justice H.R. Khanna observed that the speeches of the Constituent Assembly can be referred to for ascertaining the history of the constitutional provision and the background against which the said provision was drafted. The speeches can also shed light so as to show the mischief that was sought to be remedied and the object that was sought to be attained in drafting the provision. But speeches cannot form the basis for construing provisions. So it could be of help. It could be of help to find out what was the mischief which was to be remedied. So you find the purpose behind the legislation. So speeches, the debates, as you know, they did not, those debates and speeches did not make their way into the final, constitution. But then they tell us the purpose for which the law has been, the constitution had, added that provision. The constitutional provision was added, and in order to address what mischief. So in the light of that, then, interpretation of that particular constitutional provision can definitely be done. So similarly, Justice Bhagwati had observed in Phagu Shaw versus State of Bengal 1974 that it was at one time thought that the speeches made by the members of the Constituent Assembly in the course of debates on the draft constitution were wholly inadmissible as extraneous aids to the interpretation of a constitutional provision. But of late, there has been a shift in this position, and following the recent trends in juristic thought in some Western countries and the United States, the rule of exclusion rigidly followed in Anglo-American jurisprudence has been considerably diluted. So it's merely reiterating the idea that Constituent Assembly debates and speeches are of importance. They are of importance, but then subject to the same rule that this will not supersede what is there in the provision. The constitutional provisions will not be superseded by what has been said in what has been debated. But then they can definitely help us identify the mischief which was to be redressed. So we find the purpose for which the law has been created, and then from that and that purpose can definitely help us in identifying the legislative intent. So yes, we'll take a couple of more cases, and that should be enough for today. And in the next class we will take up statute in perimetria. So let's complete this one first. Okay, let's take a couple of cases more. Well, next important case is by the name R.S. Nayak versus A.R. Entule and another 1986 EIR 2045. And I quote what has been said. It says that the reports of the committee which preceded the enactment of a legislation, reports of joint parliament committee, report of commission set up for collecting information leading to the enactment are permissible external aids to construction. If the basic purpose underlying construction of a legislation is to ascertain the real intention of the parliament, why should the aids which Parliament availed of as such as report of a special committee preceding the enactment, existing state of law, the environment necessitating enactment of legislation, and the object sought to be achieved, be denied to court whose function is primarily to give effect to the real intention of the Parliament in enacting the legislation. Such denial would deprive the court of substantial and illuminating aid to construction. So nothing new, but the idea that external aids can definitely be referred to. They are definitely of relevance. They cannot be completely ignored, but subject to the same rule. They can merely tell you the purpose, the mischief that has been redressed. So they do not get to supersede what is clear in the statute. But if there is ambiguity, doubt, then in such situation, these extraneous materials can be referred to find out the purpose for which the law has been enacted, and then you can find the true intention of the legislature. So yes, that's the idea. So let's look at one case, okay, where Constituent Assembly debates have been referred to. But then what we will find is that even when we have these Constituent Assembly debates, it's very much possible that different judges come to different conclusions based on the same material. So to what extent are they really helpful? So it basically proves that when it comes to interpretation of constitutional provision, much more external factors play a part than when it comes to other ordinary statutes. So one very important case is by the name TMA Pi Foundation versus State of Karnataka. You know about this case pretty well. 2002 case. So in this we have two competing provisions of the Constitution. The first is Article 30 plus 1. It creates certain rights for minorities. So it says all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. So the right is to establish and administer educational institutions of their choice. However, there is another provision of the Constitution, Article 29 Clause 2, that says no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds on the grounds only of religion, race, caste, language, or any of them. So we have seen in many cases that 31 is not subject to, for example, this reservation provisions. Okay, now here we have to look at whether Article 31 is subject to Article 29(2), which is much more general in nature, and then says that no citizen shall be denied admission into educational institution maintained by the state or receiving aid out of the state funds on grounds. It says only of, okay, it doesn't say on grounds of, okay, it says on grounds only of religion, race, caste, language, or any of them. That seems to be opposed to the right which has been created under Article 31, that all minorities, whether based on religion, language, shall have the right to establish, administer educational institutions of their choice. So does that become then subject to Article 29(2)? So whether Article 31 was subject to 29(2). Now to arrive at the proper conclusion regarding the compatibility of these two apparently conflicting provisions, the judges have referred to the Constituent Assembly debate. So Justice V.N. Khare referred to Constituent Assembly debates and said that reports of the Constituent Assembly debates could legitimately be taken into consideration for the construction of the Constitution. So he referred to the Constituent Assembly debates and came to the conclusion that Article 29(2) was never intended to confer exclusive rights to the minorities, by the framers of the Constitution. So it did not create any exclusive rights for the minorities. So it seems that 29(2) is superior to the other rights. However, Justice Said Shah Muhammad Qadri came to a kind of different conclusion and held that, he agreed to the extent that, constituent, on other matters, but held that on the question of whether Constituent Assembly debates can be admissible, held that for the purpose of interpretation of articles of the Constitution, the authority of Constituent Assembly debates are of doubtful authority. So not of the same value as Justice V.N. Khare had said. So he further says, Justice Muhammad Qadri further says that that the admissibility of speeches made in the Constituent Assembly for the interpretation of the provisions of the Constitution was not permissible. So the idea is basically this, that not everything that has been spoken or debated in that form makes their way into the ultimate constitutional provisions. So on that thing says that not really admissible, not really permissible, because they are of doubtful authority, they are not permissible. Our Justice Rumapal also made a kind of similar observation and then said that the intention indicated in these speeches relating to the framing of Article 29(2) appears to be an extension of the right of non-discrimination to members of the non-minority in respect of the state-aided or state-maintained educational institutions. Further says that it is difficult to find in these speeches any unambiguous statement which points to a determination on the part of the Constituent Assembly to curtail the special rights of the minorities to Article 31. Now she is referring to the same Constituent Assembly debate, whereas it was clear to Justice V.N. Khare, to her it's confusing. So it does not in unambiguous term point out that 31 would be subject to 29(2). And Justice Vairava said, a reading of the Constituent Assembly debates clearly shows that the intention of the framers of the Constitution was that Article 29 was to apply to all educational institutions, including minority educational institutions. That means Article 30 Clause 1 will be subject to Article 29(2). So see that all the judges with respect to the same provisions were referring to the same Constituent Assembly debates and speeches, but they came to different conclusion with respect to the same matter. Now, what do we do? Is there no right answer? Well, when it comes to answer would be simply this, that when it comes to constitutional adjudications, the answer is much more difficult to provide. So what really matters in such situation is the kind of rationale, the reasoning that the judges provide us with. But that's difficult. See, the same external aid has been referred to, but the judges come to contradictory conclusion. So I can only tell you that when it comes to constitutional adjudication, external aids are referred to much more easily. Then there are other factors, that also do play a part in what is the outcome of a particular adjudication. So yes, that's it for today. So in the next class, we are going to discuss about statute in perimetry, and that would be our external aids to interpretation. Meanwhile, if you guys have any difficulties in understanding this particular part, then feel free to write to me. And the case names are stated clearly, and if you find it difficult to find them, let me know. I will share all the details with you. So that's it. Take care. Good day.